Reporting from the Law Library at the Cleveland County Courthouse in Norman, Oklahoma, I'm Dave Morris, reporting for the Oklahoman Day 32 of the Oklahoma Opioid Trial. And this morning's significance, the defense called its last witness. Today we saw 2 video witnesses, also a live witnesses. Then the defense passed it over to the state. They called one rebuttal video testimony. And then we may hear from Mental Health Commissioner Terry White after the lunch break. I think that decision is happening over lunch. Possibly this afternoon we'll hear from State Attorney General Mike Hunter, and we'll see how the housekeeping wraps up in the courtroom of Judge Thad Bachman this afternoon. As far as next steps, we're anticipating closing arguments to begin Monday morning and afternoon here in the Oklahoma Opioid Trial. Here's a few highlights from this morning's testimonies. You can watch live on Oklahoman.com as things get cranked back up at 1 p.m. here on this Friday in Norman, Oklahoma. Reporting for the Oklahoman, I'm Dave Morris.
And do you believe that there are many more out in Oklahoma who may eventually seek your services or need some sort of treatment for chronic pain?
Yes, that number is actually increased greatly over the past several years as more physicians, because of the different, whether it's the CDC guidelines, state regulation by the state board, or statements made by the Attorney General that he's coming after doctors who's prescribing opioids. That fear has left many primary care physicians saying they will no longer treat chronic pain patients and leaving these patients abandoned because there are just so many physicians available to treat chronic pain.
See that?
Yes, sir.
You may have forgotten that happened back in 2016, huh?
I did.
Okay. So you have referred to this as an epidemic, true?
Obviously, I have.
Okay. Now let's look at the other part.
And again, everyone here knows how we got to this situation. That they know we're going to prescribe, and we need to prescribe more patients, right? Had pain medicine, so we all got on board. And there's no one that hurt us. I thought that was we need to. That's his job. Not everyone deserves pain medicine.
So I'm going to make sure that's clear. I'm going to read it back. This is what was said. Everyone here knows how we got in this situation. They told us we were under-prescribing. We need to prescribe more. It's the patient's rights to have pain medicine, so we all got on board. And when someone said they were hurting, we said, okay, we are going to give you something. Now it's just the opposite. Not everyone deserves pain medicine. Did I say that correctly?
You did.
And that was you, the OSMA, CME, talking to fellow doctors and practitioners here in Oklahoma 2.5 years ago. True?
Yes.
And you were not getting paid $10,000 a day to talk back then, were you, sir?
No, sir.
And Janssen and Johnson & Johnson didn't control that presentation, did they, sir?
No, sir.
They never saw it, did they?
I don't know if they did or not.
And I don't want to know what you did or didn't do, but you've been preparing with them to come testify, true?
Yes.
Did you tell them about that presentation?
They were aware that I made that presentation.
They were, but it wasn't shown here in court, was it?
No.
So I talked to you about that knot. This is something I learned about that knot. You can really make something look hard and complex, but it takes about 1 second to unravel it, doesn't it?
Yes.
Yeah. Okay. Thank you, Your Honor. I have no further questions. Sir, I appreciate your time. Good luck to you.
We, with the permission of the court, if we will need to make a motion ready to rest, Mr. Brody.
Yeah.
And we can make that later if the court wants. I think the plaintiff has a rebuttal video they want to show. Okay.
I think we'll recognize Mr. Brody first.
All right.
We have prepared a reasonably short brief that addresses the additional reasons why we believe the court should grant the motion, building upon the evidence that has been presented during our case in chief. The grounds for that are fully stated in the brief that we will be filing. I believe it's probably being filed right now as I'm speaking on this motion. Very briefly, the grounds are that the evidence is insufficient to prove a public nuisance, that the state's claim is barred by the First Amendment, that both federal law and state law bar liability for Naramco and Tasmanian Alkaloids sale of active pharmaceutical ingredient, that the state's claim is preempted by federal law, that the evidence is not sufficient to show that the defendants were a cause of the opioid crisis in Oklahoma, that the state's own role entitles defendants to judgment, that the evidence shows that defendants cannot be liable for the entire Oklahoma opioid crisis because the state did not prove an indivisible injury and because imposing joint and several liability would violate due process. And finally, that the state's abatement remedy is not available here, is unsupported by the evidence, is barred by the Oklahoma Constitution, and violates both the due process and excessive fines clauses of the U.S. Constitution. And all those reasons and the grounds therefore are fully set out in the brief that is being filed with the court. We will understand if the court wishes to take that under advisement, but we request that if the court does so, the court does so without waiver of any rights and any of the arguments that we are presenting in this motion. Thank you.
Thank you, Mr. Brody. What we'll do is we will resume at 1 o'clock, and Mr. Brody, you can renew any objection you have at that time. All right? Thank you.
Thank you.